Hello and welcome to another episode of the Small Agency Talk Show. I am Chip Griffin, the founder of Saga, the Small Agency Growth Alliance, and I am delighted to have with me Sharon Toerek, a regular panelist and the founder of Toerek Law. Welcome to the show, Sharon.
Happy New Year, Chip. It's good to be here.
Happy New Year to you too, and it's an exciting year. It's not exactly what I think most people were expecting slash hoping for in 2022, but it is what it is, and we will soldier forth no matter what.
We're here for it either way, right?
Exactly, right. I mean, that's the good news. We're here,
Absolutely.
and so why don't you share a little bit about yourself for listeners who may not have heard you before, and where they can find you.
Absolutely. Thanks. I am the founder of Toerek Law, otherwise branded legal and creative for the agency world. And we help agencies across the U.S. manage their intellectual property, turn their assets into revenue, and address their legal affairs. And so our clients are independent, small and mid-sized agencies across the United States primarily. I'm also the host of the Innovative Agency podcast, which is a podcast directed um, for agency leaders and not on legal topics. So we talk about all kinds of cool stuff like technology, business development, creativity. Once in a while, I get a chance to slide in there with a little bit of a legal observation, but it is not a legal podcast. So that's the Innovative Agency. And then I also created the Agency Protection System, which is a legal membership-based toolkit for marketing agencies.
And the podcast is fantastic. They are tremendous conversations, as you say, that are not all about the legal aspect
Thank
of
you.
things. So you really dive into pretty much every aspect of the agency world, and so there's lots of good content there. So I would encourage listeners to subscribe to that as well.
Thank you very
Um,
much.
Today, though, we will be talking about legal topics.
Yeah.
And if you are watching us live and you have any questions or comments, feel free to share them, and I'll try to incorporate them into the show. If you're watching after the fact, well, we can't incorporate it into the show because we don't have that technology where we can turn back time. But I'd be happy to try to answer your questions in the comments on whatever platform you consume this on. So with that, let's jump into the topic today. And we're going to key off of a blog post that you wrote recently, Sharon, where you talked about 5 must-have documents that every agency should have in their toolkit. And I think while legal is not the kind of thing that agency owners wake up in the morning and say, oh, I really want to think about the legal aspect of my business today,
Right.
it's really important. And the more preparation you have for it, and we were talking about this pre-show, the more preparation that you have on the legal front, the less stressful it is when you do have issues that arise.
Yeah, our philosophy is that legal should not be a headache for agencies, that actually legal should make it easier for you to run your agency. It should make it faster for you to close that next deal or bring on that next freelancer. It should be a revenue stream for your agency, not an expense or an impediment to doing something that you want to do. And so, one of the best ways to do that is to make sure you've got a solid foundation in place. And every agency's solid foundation starts with the critical legal documents that pretty much every agency needs, whether you are focused on digital, PR, creative. This is a set of tools that really may need to be adapted to your specific offerings, but that every agency really needs to have in its toolkit to advance business forward, promptly.
And before we get into the specific documents, I think the other key thing that you sort of have touched on there is that you really need this partnership with the lawyer that your agency has. And so that really means developing a relationship so that you each understand each other. You help your lawyer understand what your philosophy is, what your risk tolerance is. You start to understand from your lawyer or your legal team, how they approach things. And the more that you get in sync on that, the easier it becomes. And the more it turns into a fruitful, productive, profitable relationship rather than simply someone who ticks whatever legal checkboxes you think you need at that time.
Agreed. Yeah, the most challenging thing for agencies that I talk to who are looking to engage counsel or evaluating their relationship with counsel is that you should pick an agency an attorney, a law firm that really understands how agencies work and how you make money and what your business models are, because they're very different than other industries and other small businesses. And so, and the reason I say that is, is look past the obviousness of that, to the point that you are going to be much more likely to want to include that legal advisor, or in the case of money, an accountant or good financial advisor, whatever the discipline might be. You're going to consult with them on a more routine basis. You are going to bring them in on a more frequent basis, and they're going to understand you, your team, your culture, the type of business you have, the way you make money, the things that that keep you up at night. And so it's just super important when you're picking an advisor in general. And if you pick the right advisor, they are going to help you put this infrastructure in place. That means you're not going to have to call them as often, and when you do, they're going to be familiar with what you need and why you need it.
Right. And I think that, finding someone who really understands the agency world, professional services businesses, the kind of things that you do and the documents that you're going to need makes a big difference. It's great that you might have a cousin who's a lawyer, or your uncle's next door neighbor happens to be a lawyer, but if they're not involved in working with businesses like yours, it's not going to produce the same results as someone who actually understands the core business that you're engaged in.
Yeah, I mean, it's a cross section. It's not just about understanding the particular legal issues, but it's also about understanding your industry. And
Right.
look, if you were a medical practice or a dental practice or a manufacturer, you would want advisors who understood what you did, what you sold, how you did business, what your culture was like. And so, that's just those common sense principles of pairing yourself up. But the key is it's also the best way to save money on those
Right.
investments that you're going to make in those services, because they're not going to be a slow study. And I think one reason why agencies perceive something like legal as an investment, an impediment, a reason to roll eyes and get nervous about writing checks is that they don't really think of it often as a proactive strategy to advance their business forward. They're sort of coming at it with a mentality of um, the last possible resort is having to send this to the lawyers to work out. Let's try, to manage it as a business issue up until then. And sometimes you can do that, but the risk you're taking is that the risk you take with that kind of mindset is that over time you're going to pay way more money in professional fees. And you're also not going to get a result as quickly in most cases. And the process is going to be a little bit more stressful.
Yep.
We've seen it time and time again. And I'm sure an accountant who would be talking with you, Chip, about this issue would be saying the same thing.
Absolutely. And it really is the same thing. That legal and accounting are two of the most important things that you need in running any business. They're
Mhm.
not the most exciting things, but if you get them right, it's going to help you grow faster, grow more profitably, and really reduce that stress level, which is important. So
Right.
let's
Exactly.
talk about the 5 documents that you think that an agency should focus on making sure they've got in place to keep them out of trouble, or at least reduce the amount of trouble that they can get into.
Sure. Yeah. Well, let's start with the documents that raise the most questions for our clients, and actually lead to this being probably the most frequently requested service at our law firm by agencies, and that's the master services agreement. You might call it a professional services agreement, a letter of agreement, whatever you call it. The master services agreement, which is sort of your Bible as an agency of how you contract with your clients. And the reason it's such a critical document, and the reasons why you should have your agency's own master service agreement, are there there are multiple. First of all, most common objection I get when I talk about this at a conference or when I'm, meeting with a group of agency owners is, most of the time we end up signing the client's MSA. And so we're not really seeing why it's to our detriment to, not invest in one of that's our own. And my response to that is that, first of all, even if in many cases you end up having no choice but to sign the client's MSA. Well, actually, I'm going to back up. First of all, it's not necessarily true that you're going to end up having to sign the
Right.
client's version of an agreement if you get to the table first with a well-drafted MSA of your own. Secondly, it's not always true that the client is going to insist upon their paper over yours, but even if they do, that's your benchmark for how you're going to negotiate off of the client's master service agreement. Having your own and going through the exercise of pulling together your own client services document is going to help you understand how to be a stronger negotiator, how to make a fairer deal, how to spot the trouble areas in the client's contract when it's presented to you, and to understand what are issues that are, nice to haves, what are imperatives, and what are things that are more boilerplate and aren't really issues that your agency needs to care about. So it's the most essential document, and actually agencies usually mean more than one format, because in our experience working with independent agencies, you've got those clients who you have ongoing or bigger dollar relationships with, and they need a master service agreement because there's going to be multiple projects, there's going to be multiple deliverables. But every once in a while, there are, though, actually not every once in a while, more frequently these days in the agency world, you're going to be engaged first, to date before you marry. And so maybe it's just a project. In that case, you're going to need a shorter form set of terms and conditions. That's the second most important legal document that you need, because a client is not going to want to sign a master service agreement for a $10,000 project.
Mhm.
Or because your agency is not going to want to invest the amount of effort it takes to negotiate a master service agreement for a $10,000 project. So a shorter form set of legal terms and conditions that you can add to either your estimate or your proposal, that is an abbreviated set of the most essential terms that you need in place in your client relationship, is a really wise document to have in place.
Yeah, and I think you've made a good point here that the type of documents you need may vary based on the kind of engagement. It also depends on the clients and brands that you're working with, right? Because you spoke earlier about client agencies saying, well, why do I even need to do this? I'm going to sign the client's agreement anyway. Those are the largest clients that are doing those kinds of things, right? The vast majority of businesses that hire agencies don't already have their own standard agreement, right? Certainly the big name ones that we all
Yeah,
recognize and you see the logo and you're like, oh, I get who they are. That's
yeah,
fine. But a lot of small agencies are doing business with plenty of medium-sized businesses that don't have that kind of legal department. So you
right.
absolutely ought to have your documents in place so that you're driving that conversation.
Yeah, I mean, look, you're going to show up differently to that negotiation or conversation with a prospective
Yep.
client if you have your own master service agreement. The client's going to understand your level of sophistication as an agency about, and that doesn't mean, I don't mean sophistication equates to legalese or a lot of boilerplate that isn't necessary or a document that doesn't feel reader friendly to you. Because there are lots of ways to avoid that objection, but sophisticated in terms of understanding the legal issues that really matter to the agency and the relationship, and where you need to protect yourself. So if you show up differently if you have your own MSA to the client conversation. You, like I said, you've got a built-in set of benchmarks for how to evaluate if you're going to be reviewing and negotiating off of the client's document as well.
It also can speed the process along, right? Because if you've got something already ready to go, you don't go from the point where the prospect says, "Yes, I want to work with you," and then you say, "Okay, well, let me pull together a contract or an agreement," and it takes a week or two to pull something up, and then all of a sudden, all sorts of things can go off the rails. So if you've got something in place and you can just plug in, the details and ship it over within 24 hours, you have a much greater likelihood of not seeing that opportunity go off the rails.
100%. It streamlines your sales process. It's an example of legal as a revenue center for you because it's going to help you get that deal on the table faster, and it's going to reduce friction to getting that first installment on that retainer or to getting that deposit on that project. And that's typically what most agencies are concerned about when they bring legal into the process of signing up a new client is we need that money in the door. And the longer an agreement we give to them, or the more complicated a document we give to them, the longer it's going to take before we get that, retainer signed and start that money flowing into the door. And it doesn't have to be the case. It can actually, it frequently is the opposite case in our experience.
Yeah, and at the end of the day, legal's role is to help facilitate the business objectives,
Yeah.
right? And I think a lot of folks are afraid of lawyers because they're like, well, they're going to tell me I can't do this. And good lawyers don't tell you you can't do this. They say, here's how you have to do it if you want to do it, right?
Exactly.
And so the role is to find a way to facilitate the process, find the path forward, and if you're doing that, legal actually is that profit center that you talk about.
100%. We're not there to be obstructionists. We're there to help you achieve your business objectives.
Absolutely. All right. So what's the next document that I need to have in my arsenal?
So the next document is you need to look at your client onboarding documentation in a modular fashion. So the next document is really a well-drafted statement of work, and you probably need more than one version of this document. If you're an agency that is multidisciplinary, you provide not only media buying, but creative, or you do digital, plus you do social. You need either a very flexible statement of work template that will enable you to customize it to each transaction, or even better, adapt yourself your standard SOW to customize it for various types of work that the agency does on a regular basis. So you've got a couple versions of your SOW that can be plug and play for, digital, social, influence, creative, branding, whatever it might be. That paired with your MSA, or that paired with your estimate, that's your client document set. That's the Bible of how you all are going to do business together and resolve any disputes that might arise or clarify obligations and responsibilities. So well-written statements of work and I always like to tell clients, remember, the statement of work is where you put deliverables, timelines, and money.
Mm-hmm.
Deliverables, timelines, and money. All the other legal terms, those go in the MSA. And so keep deliverables, time, and money out of the MSA and in the SOW, and use the MSA really as the legal guidelines for your relationship. Use the SOW to describe the business particulars.
Yeah, and the advantage of this setup is that if you've got the master services agreement, first of all, your standard one doesn't need to be changed all that often, right? Because once you sort of set it once, occasionally you may need to make changes based on changes in the law or the way your business is operating. But for the most part, that's going to stay the same. The SOWs, those are things that can morph over time as your business is changing, but it's a much smaller, tighter document. It also is something that you can adapt as you learn from client engagements. So if there are things that come up as disputes with a client, usually it's based on what's in the statement of work, and so you can adapt the next one that you do for that client or for another one to make sure that you're accounting for that. So to me, the statement of work becomes a more fluid document. The other advantage to doing this bifurcated process is that it allows you to bypass a lot of the legal review if you take on a new project for a client, right? You're not reviewing this lengthy legal contract. You're just reviewing a 1 or 2 page statement of work in most cases.
I was just going to mention that I like to think of this as a modular approach to your documentation of client relationships. And remember, your MSA may be for a multi-year term. It might be for a term of a year. It could be a term of 3 years. And every time you do a new project, you're not going to go to the drawing board again and sign a new MSA. Use that SOW to describe deliverables, timeline, and money. And every time you get a new project, then you just put a new SOW together and you reference back to the MSA. So it greatly abbreviates the process of taking on a new project and defining what the parameters of that are going to be.
Yeah, and my experience too with SOWs is it takes a little trial and error for your own agency to figure out how detailed your SOW should be, right? Because there are pros and cons to the level of detail that you put in there. And so you want to make sure that there's enough that there aren't misunderstandings, but not so much that you're putting yourself in a box, and that you still have some flexibility. So you want to think things through and make sure that you're reviewing it periodically to say, okay, what have we learned from our past few engagements that we need to apply to the next SOW we draft?
Yeah, and I will tell you, we've seen hundreds of versions of SOWs. They are extremely reflective of the agency that puts them together. Every agency likes to inject its own personality and client speak into the SOW. I understand the urge to humanize the documents. I would just encourage limiting the marketing speak. At
Yep.
that point, you've already sold the client, right? Or you haven't, and you have, or you wouldn't need to be putting these documents together. So, um, really focus on the business elements of the relationship, and
Exactly.
save the marketing speak or the culture speak, in my view, for the proposal. Maybe an estimate, not necessarily for the SOW.
Right. And remember, whatever you're putting in the SOW is a promise. It is not marketing fluff. It is an actual commitment that you're doing exactly what you say on exactly what timetable you say. So,
Yeah,
keep that in mind when you're writing it as well.
agreed,
So,
agreed. Yeah.
which also means if you've got separate people who are doing business development and client service for your agency, make sure the client service people are involved in the drafting of the statement of work so that they know what they're committing to or what you're committing them to, so that there aren't misunderstandings internally. Because I've seen that as a common cause of strife on the talent side of the equation.
Can we talk a little bit about process overall? Actually, you
Sure.
raised a good point there, and centralization. The number two way to save yourself time and money in the client documentation process is use a library of the same documents deal to deal. Of course, you're going to have to adapt them to the specific
Yep.
project or client, but don't reinvent the wheel every single time you are onboarding. That's first. Secondly, limit this role in the agency to as few people as necessary. Don't have 10 account execs putting contracts together, because you know what you're going to get:
Right.
10
10
different
different. Yep.
contracts.
Yep.
Um, have a centralized library of these documents. Make sure everybody who is empowered to actually engage in putting these documents together know where they are. Have a process for them tracking changes and requesting deviations from what your standard processes are, and limit it to as few people in the agency as necessary. And if you're really small, maybe that's you and your right hand person.
Hmm.
If you're a larger small agency or a mid-sized agency, it might be your operations or your finance team. Whoever it is, the last thing you want is a cowboy approach to this, where everybody, your AE who just came to you from another agency really liked the contract that they use there, and so
Right.
they're using something. You would not believe how many times this happens. And so centralization and consistency, another way to save a ton of time and money getting this done, and avoiding risk and mistakes that you don't want to make.
Well, and if you ever dream of selling your agency, it will also help you a ton when it comes to due diligence if you've got some consistency amongst the documents. And oh, by the way, if you've got a decent filing system, so you know everything that you've actually signed. But that's a topic for another day.
That's true.
Because that's a fun one that I've seen when I've tried to acquire businesses. So,
Absolutely.
all right. So next up on the document list.
Yeah. So speaking of internal processes, the next important document for every agency needs to have is a document with their employees. I'm going to loosely call it an employment agreement. Not every agency needs an actual employment contract, because most of you are engaging with employees on an at-will basis. And so you're not engaging somebody for a specific term or committing that the relationship is going to last for a specific period of time. However, what you do need in place is an employment agreement, what we call a business protection agreement at our firm. And we call it that because it covers those covenants that you need an employee to make to protect your business: confidentiality, non-solicitation, which means that they are not going to leave your agency and try to take your clients with them. Um, it's more and more rare these days that non-competition is appropriate, but if you still live in a state where non-competition covenants are enforced, sometimes non-competition, and also clarification of your intellectual property policies. Reiteration for the client that the work that they're doing belongs to the agency, not to them. That requires them to ask you for permission to display it in their personal portfolios. So all the sorts of things that could do the business economic harm or interfere with its intellectual property or its client relationships should go in an employment agreement between you and your employees. And we call it a business protection agreement because when you say employment agreement, it's sort of, not sort of, it definitely implies a term, a specific amount of time that you're committing to each other,
Right.
which I do not recommend for any agency.
Right. Yeah. I've always just titled it employee covenants, but what it doesn't matter what you call it. You want to be careful that you're not creating an actual contract, because I have seen too many agencies do actual employment contracts where they're effectively committing to both terms, and in some cases I've seen them specify specific benefits, which can become problematic because then you've got different employees who are promised different benefits, and so don't do that.
Right. Your
You've got
best,
at will
yeah,
employment. Refer back to handbooks and policies and things like that. Don't say, we're going to give you this insurance policy for this amount of money and things like that, because that just is a whole can of worms you don't want to get into down the road.
totally. It's, again, it's a modular approach, and you'll find over time, if you're consistent about this, just about everything in terms of agency legal contracts is a modular situation. And so have a high level offer letter to new hires, along with your employee covenants or business protection agreement, whatever you call it, that covers those restrictive
Exactly.
covenants that need
Yep.
it. And then, this isn't the time or place, but the handbook is the place where you flesh out some of the rest of that stuff.
Exactly, because some of that stuff's going to change over time, right? I
It
mean,
is
first of all, health
fluid.
insurance you have very little control over as a small business these days.
Yeah.
So you don't want to be promising things that you can't do. Plus, economics can change, and your office policies can change. All sorts of things can change. So give yourself the flexibility for those to adapt over time, and only put in the commitments the things that really need to protect you as the agency from the things that you've just mentioned.
Right. Right. So, I mean, and so continuing their tour internally through these documents,
Yep.
every agency we work with, I'm sure, Chip, every agency that you have served works with freelancers and independent contractors.
Yep.
So,
100%.
crucial document, independent contractor agreement. And I'll answer the number one question right up front that we get about these. Can you use the same document for employees and for contractors? No. The short
They're
answer is
different.
no. They are different
They
legal
better be different, because the
relationships.
IRS and the state agencies really frown upon them being the same thing.
Well, and you absolutely, I mean, one of the reasons why you have a process of putting a contract in place is because it is one of the IRS elements working in your favor as an agency to classify these individuals as independent contractors. So that's crucially important from a tax compliance reason. But the number one reason, from my perspective as an IP warrior who just happens to have developed an agency focused law firm, is no matter whether or not you paid a freelancer or a contractor, if you don't have something in writing that says you own the rights to the work they've created for you, you don't own the rights to the work they've created with you. That's how the copyright law works in the United States and in most Western countries in the world. So if you've promised something to your client that they're going to own the rights at the end of the day too, but you don't have the rights yourself from the contractor, you've sort of broken the chain of custody there. And that's a legal problem in the eyes of the copyright law. So for all those reasons, for IP, for clarification of portfolio use, for restrictive covenant reasons, and tax compliance purposes, you need an independent contractor agreement. It's actually worse. Well, this is a judgment call on my part, but if you want a desert island, you can only choose one or the other. I would make sure you had an independent contractor agreement in place before I would worry necessarily about the employment agreement. And that is because there's lots of common law that protects you in an employment law situation by default, even though you need both, because they're both equally critical to your business. So, independent contractor agreement for freelancers.
Yeah, and I would absolutely agree with you. To me, it's not even a close call between the two, independent contractor, and I want them both. But if I had to
Yeah.
choose, it would be the independent contractor agreement. I mean, there are far more occasions where I've seen businesses, have to do something to enforce an independent contractor agreement than to enforce employee covenants. Right? Employee covenants, for the most part, are just kind of threatening letters, if you will. Whereas independent contractors, you can sometimes run into more serious issues, and so I like seeing that document first.
Well, also, for legal purposes, in terms of, let's just talk about IP quickly for a moment. If somebody is your employee and they've created work for the agency or your clients within the scope of their employment, the copyright law automatically puts ownership of that work in you as
Right.
the agency employer. So it's not a question. It is a very big and open question under an independent contractor relationship. So it's a document that's got all these contractual covenants in it is the way to clarify those issues, and also what gives you the leverage to enforce some of these things when you've got contractors, because most contractors don't obviously work just with your agency. They have other agency clients who, and they might work directly with brands as well. So, you know, you want to be really clear what the swim lanes are in terms of what work they can display. You want leverage in case you need to ask them to take work off of their portfolios. You need leverage in case they are talking with your clients privately about doing work directly for them instead of through the agency. And the independent contractor agreement is what gives you all of the leverage that you need in that situation.
And at some point, we probably could and should do a whole episode on the independent contractor relationship, because there are a
Right.
lot of things involved with that. Everything from classification, which frankly a lot of agencies get wrong, to how you put these things in place so that you're protecting yourself, particularly if you're like a digital agency or something like that, because a lot of the developers and designers you use will reuse code from project to project. You want to make sure that it's licensed correctly, and that there's all sorts of that you don't step on any landmines there. So, but we have run just a little bit over time here, but I do want to make sure that you have a chance to disclose the final item on the list.
Final, we're looking externally again, mutual non-disclosure agreements. Very important for agencies in new business development situations, so that if you are expressing ideation or showing concepts, that you are protected from a prospective client taking that stuff, using it, implementing it without your participation. And some agencies are also well served having a special mutual non-disclosure agreement for independent contractors, because what happens sometimes is you bring that contractor in to help you maybe pitch a piece of new business, or before you've actually signed the client agreement for a project. So you've got an NDA in place with the contractor ahead of time, even though you'll have confidentiality language in the actual independent contractor agreement. Sometimes it's good to have a separate version, but the crucial one is the one between the agency and a prospective client.
Right. And make sure this is just like the MSA, make sure you have your own. This is most times my experience is clients, if you offer it up and you get it over to them first, they'll go ahead and sign whatever you send. Because most people are just happy to have the agreement in place. But you don't want to go willy-nilly signing someone else's non-disclosure agreement, because a lot of times what they'll send you is not mutual. You should pretty much never ever sign a non-mutual non-disclosure agreement, in my view. It should
Absolutely.
almost always be two ways. It's hard to think of a situation where I would say sign a one-way one. But you also, there are some folks, some lawyers who like to just drizzle in a little bit of extra stuff in their NDAs that has nothing to do with the actual non-disclosure agreement, and may have things to do with non-solicitation of employees or things like that. And you don't want to be committing to stuff like that if you're just trying to have a conversation, right? Don't go wandering
Yeah.
off into the wilderness and signing someone else's agreement if you can have your own.
Well, and I also like an express acknowledgement in the mutual non-disclosure agreement that the IP and ideation that the agency is presenting is its own IP unless the parties agree otherwise. And so that is adjacent to sort of the non-disclosure commitments that the parties make to each other, but the mutuality is the biggest point. The
Right.
only way to be sure it's mutual is for you to present one to them that is mutual.
Exactly. Again, it's like everything else, it speeds the conversation along, because if you can get this over to them and all they got to do is sign it, often electronically these days, which is nice, you can just go ahead with your conversation. You don't have to delay things and get lawyers involved and all that kind of stuff. Just have your standard document that your lawyer has vetted and says this is a good document, get them to sign it, and done deal, move on.
Yeah, and I would say too, that if you are of the mindset that using NDA in the business development phase of the relationship makes you look difficult to do business with, or doesn't make you seem laid back or enough as an agency, because we do get that objection a lot from agencies. We don't like the tone it sets. We're just not going to do it. There are some other, I would encourage you to get over that, first of all, because they're not shy about shoving their version of it across the table at you to sign. They're used to getting these and signing these. And all it makes you look is knowledgeable and sophisticated about the value you're bringing to that conversation. So
Right.
there's some other things you could do if you don't have an NDA, but we don't have time to talk about those today.
Right.
Use a mutual NDA. Have it as part of your toolkit.
Yeah, and like I was saying earlier, make sure you keep track of all the NDAs you've signed, because
Yep.
that's another one that you can end up tripping over, particularly, once you start to grow, 10, 15 employees, and you get things that are signed and someone doesn't realize that you've signed an agreement in one place and it may impact on another. So really, keep track of all the legal documents that you're signing, and
Yep.
and have a centralized repository for it, so that
Yep.
you don't get surprised in a nasty way down the road.
Right. Consistency and centralization, key to success and key to saving money. Actually, it'll make you money too, because it'll get your deals done faster.
And I think that's absolutely the key, right? I mean, you use legal to grease the skids and accelerate your business, and you will have a successful agency. All right. So with that, we've gone a little bit over time today. Sharon, I appreciate you taking the time to share these, because these are important documents that every agency should have in place. It's not all you should have in place, but these are 5 critical ones that will help, if not keep you out of trouble, at least protect you when trouble does pop up. So.
Right.
With that, my guest today has been Sharon Toerek of Toerek Law, legalandcreative.com. You, of course, can find past episodes of this show at smallagency.tv, and you can learn more about Saga at smallagencygrowth.com. I'm Chip Griffin, and that will bring today's show to a close, and I will see you again next Friday.